The broadcast is now starting. All attendees are in listen-only mode.
Good afternoon, everyone. This is Katie Otto, Director of Communications for Juvenile Law Center, and we are very pleased to have you joining us for our Juvenile Justice 101 training and phone call for reporters. Thank you very much. We see that a number of people are also here promptly, so we really appreciate it. We're just going to wait about another minute for some people getting on the call. For the first 30 minutes of this call, it's going to be a presentation by Jessica Fireman and Ria Shah. And then the last 30 minutes will be a question and answer moment. You can either type questions. I think the most effective way would probably be to type questions in, although we will try to also open up possible questions over the phone too. So just please hold tight for one more minute and we'll be getting started. Okay. All right, and now I'm going to be handing this over to Ria and Jessica because we want to be respectful of your time. So take it away.
Hi, everyone. Good afternoon. This is Ria Shah. I'm Managing Director at Juvenile Law Center.
This is Jessica Fireman. I'm the Senior Managing Director here.
And we want to welcome you all and thank you for joining us today. So just to give you a little bit of background information about Juvenile Law Center, we are an over 40-year-old organization. We started out here in Philadelphia by 4 graduates of Temple Law School, and it was started as a legal services organization for children within Philadelphia. So representing children in court who were, in the foster care system, youth who were expelled from school, youth who were truant from school, youth who were in the juvenile justice system. And very early on in our tenure as a legal services organization for children, we recognized some policy that were affecting children on a large scale, and we began conducting some impact litigation to address these issues. And since then, the organization has really evolved into a national organization that does more policy work on behalf of children in both the child welfare and the justice system. Our mission is to fight for the rights for children who are in these systems, and to really make sure that the systems that are intended to protect children are doing so and not harming them in the process. So our work, as I mentioned, spans both child welfare and justice. That's youth in the juvenile justice system, as well as children who are tried as adults in the criminal justice system. And that's going to be the focus of our conversation today, just giving you a little bit of background information about the youth in these systems and the work that we do. So I'm going to turn it over to Jessica.
So as you can see, the goals for today is to give you a little bit of background about the juvenile court. I think it's easier to understand what the court is all about when you know where it came from, to give you an overview of the juvenile justice system and how it works, and then to talk about some of the hot topics that we see coming up more recently. So you can see here, if you want to learn more about Juvenile Law Center, obviously our website at jlc.org will tell you more about us, and you can dig a little deeper into our topics. You can see some of our litigation and our policy work. To give you the broad background of what's happened in the development of juvenile court over time, we started at common law when essentially if you were a small child under 7, you were treated as a child, and 7 to 14 years old were, there was more nuanced discussion about what would happen to you, and 14 or older, that's an adult. But that's way back. We typically look to the origins of the juvenile court as 1899, which was the first juvenile court in Cook County, Illinois. Then there was a period of constitutional rights. I'm going to talk a little bit about each of these in a minute. In the 1960s, that continued on. There was a real emphasis on punishment in the 1980s. And then starting in the 2000s and continuing today, there's been a focus on science, and particularly the science of the adolescent brain. So I won't go into a lot of detail about any of this, but I do want to give you some highlights about the early juvenile court. So I mentioned that 1899 was the first juvenile court in Chicago. And the concept at that point was to address the need and not the deed. So this is a sort of first notion of a rehabilitative court specifically designed for young people. That's important because we still see remnants of that court today. It's also worth noting that even at that time, if you look back, there was a lot of talk about urbanization, the threats of urbanization, the threats of immigration. So what we in some ways cast as sort of a positive rehabilitative court also from the very start had problems with racial disparities and with disparities based on immigration status. So that court kept going on. The boy in the middle on this slide is Gerald Galt. So if any of you have worked in this field, you'll have heard of him. He had a seminal case in 1967 where he made a lewd phone call to a neighbor, and he was taken into juvenile court with no due process, no counsel, none of the rights that we now see in our juvenile courts. And his case went up to the United States Supreme Court, and the court ultimately held that the condition of being a boy does not justify a kangaroo court. In other words, kids still have constitutional protections. And again, this is important because the Galt case is regularly cited now as we talk about what those rights should look like for young people in court. There were a slew of other decisions around that time in the 1960s that defined the parameters of what are the legal rights that young people have. But at base, what we know is that there are constitutional protections, and just being in juvenile court doesn't mean that the paternalistic impulses overcome the need for due process. In the 1980s and 90s, there was a real focus on criminalization and punishment. There was a fear about the rise of crack cocaine. Folks may have heard of the super predator myth, this notion that young Black men were a real threat and it was on the rise, and there was going to continue to be more and more crime. And the only way to solve this problem was just to lock up young people, and that was our way out. It turned out to be completely false. The social science research that suggested that there was this wave of crime that was going to overtake us and keep rising for years. In fact, since the 1990s, as you can see here, the rates of incarceration and arrest, well, you'll see the arrest rates here, but arrest, incarceration, justice system involvement is down for all youth. One of the really unfortunate things, though, is that that was a moment of heightened incarceration, particularly of Black and brown youth, and that, again, when we think about what's happening in our justice system now, we're still seeing the impact of those policies. Many of those statutes have been overturned and many are still on the books. So the phase that we're in now is a phase where adolescent development is central. I have here MRI images of the developing brain. The more purple it is, the more fully developed the brain is. And what we learn from social scientists and neuroscientist friends is that the frontal lobe, the part of your brain in charge of executive functioning, making decisions, continues to develop well into a young person's 20s. And so as we think about what the law should look like, the courts began to take note of this. And so we don't hold a young person culpable in the same way as an adult. That is true in We've seen it in the elimination of the death penalty, in the elimination of certain life without parole sentences. And it's also true in the way we think about creating our juvenile justice policies. So we're really in an era now where courts and policymakers are looking to science and adolescent development in framing how we respond to young people.
So now that you have a bit of background on where the juvenile court system started and what it looks like a little bit more today, I wanted to walk you through the path that a young person goes through when they're in the justice system. So the first stage is the stage of arrest, but we also have here a petition. So the difference in the juvenile justice system here is that anybody can really petition the court for, to claim the child as delinquent or in need of services from the juvenile court. And so the child could get involved in the juvenile court system either through the arrest, a standard arrest that you would that you all can imagine, or a petition for delinquency. And one thing to note here is that in the 80s and 90s, as Jessica mentioned, there was a rise in policing young people, as well as just in the incarceration rates. And so that's when, through then and later through the Gun-Free Schools Act, we saw a rise in zero tolerance policies in school, and school police officers addressing some school-based behavior that would ordinarily be addressed by administrators and disciplinary authorities within the schools. So that leads to a lot of the disparities that we're seeing in the justice system today. So once a young person is arrested or there's been a petition filed for their delinquency, they are brought in and there's then a detention hearing. So at this stage, this is sort of like pretrial detention that you might hear of for adults. The system generally is very similar now to the adult criminal justice system. A lot of the language is just a little bit different. So at the detention hearing, the judge makes a determination about whether or not the young person should be detained prior to their hearing or whether they can go home to their families. Now, there's no bail for the most part in juvenile court, so this decision is really made based upon the support system that the young person might have at home. So for a child who may not have parents who are home all day or able to monitor them throughout the day, may be more likely to be detained. So we see a lot of disparities in the number of youth who are being detained pre-trial as well. So now the next phase after the detention hearing is excuse me, the adjudication. And the adjudication is a determination by the court that the young person is involved in the crime or was not involved. And so that's an adjudication of guilt or innocence, essentially. This is the trial. This is a typical trial. There's evidence presented on both sides. The prosecutor is on the other side. The young person may be represented by a public defender or another attorney. Although the hearing has severe consequences in terms of what might happen to the young person if they're found to be adjudicated delinquent, there is a little bit more informal. It is a little bit more informal than what you might see in a trial in adult criminal court. And that means that the rules of evidence, although they apply, the judges might be a little bit more lax. And some of this goes back to what Jessica was describing in early juvenile courts, where it was a very paternalistic view, where the judge is really looking to see what the best interests of the child might be and whether or not they need to be taken from their homes and placed into a community. The next, into a community, non-community setting where they're in a placement facility. So the next phase after adjudication is disposition, which is similar to sentencing in adult court. At this stage, they might make a determination that the child needs placement. So that's like incarceration. They could be placed in a treatment facility if they need behavioral health treatment. They might be placed in a secure detention facility, which is similar to an adult prison, or there might be a determination that they need probation or some sort of other community program involvement. And then they place the young person on probation, which is an opportunity for them to kind of demonstrate their ability to abide by the conditions and terms that are placed on their probation. And then once the probation, and then they meet with their probation officer, and they might have to engage in some certain skill building, and then they would be released. So this is just an overview of the path. There are some areas in which there are opportunities for the young person to be taken out of the system. So after arrest or even after detention, sometimes there's what we call diversion, which is a program where the young person is taken out of the juvenile justice system, and they might have to do some sort of probation, some early pre-trial probation, where they have to abide by certain terms and conditions, or they might be placed into a diversion program where they have to do drug treatment or some sort of other types of treatment programming, but then they don't get a juvenile record. They don't have the whole, don't have to go through the whole system if they're diverted out of it.
Just one additional point on the words that we've included here, and this is something that we notice in journalism regularly, is it tends to be that people are used to the adult system. So they talk about crimes, criminals, they talk about sentences, they talk about trials. And so these words are ones that we use very intentionally. An adjudication is not the same as an adult trial. A delinquent act is not the same as a crime. A disposition is not the same as a sentence. We've made a decision as a society to treat these, to treat young people differently, and those are words that signal that.
So now we're going to go into a little bit of the work that we do here at Juvenile Law Center and give you an overview of that work, the issues that we're currently addressing within each of these project areas, and some of the issues that we think might be arising over the next few years on these issues. So we're going to start with fines and fees.
This is an issue that many of us have been paying a lot of attention to, especially in the wake of Ferguson, with the recognition that fines and fees were pushing adults into the criminal justice system. Juvenile Law Center in 2016 did a report looking at every state to assess the statutes in those states and determine whether young people were similarly facing fines and fees, and especially were those fines and fees pushing them further into the justice system in a way that mirrored what we were seeing in the adult system? And the unfortunate answer was yes. You can see here the website, you can click on individual states to get a little bit more information. But what we learned was that there was a really widespread practice of charging young people money in the context of their juvenile court involvement or charging their families, and that it led to really problematic consequences. At worst, being locked up for failure to pay, fairly frequently being held on probation longer because you can't pay fees, and then in a terrible sequence of events, getting stuck on probation because you can't pay the probation fees, so extended time in the juvenile system, and also real pressure on families, and tension in the family, because we have high bills coming from the justice system that people can't afford, and they're deciding, should I pay for my groceries? Should I pay for my other child's school uniform, or do I pay the court fee? I'm happy to say that this map is now slightly out of date. You'll see Nevada has the correct color for 7 different types of fines and fees, and they just unanimously passed reform out of both houses that was then signed by the governor, and they've eliminated the vast majority of fees all fees in the juvenile system. So they just have fines and restitution remaining, and we are seeing and participating in a real effort around the country to eliminate fines and fees, and we're finding that states are receptive. So you can expect to see a lot of reform in local jurisdictions and at the federal level on this issue in the coming year.
The next issue that we wanted to talk a little bit about is juvenile records. So you'll see similar maps to the maps that Jessica just described. And in this study, we looked at every single state's laws around confidentiality of juvenile records and expungement of juvenile records. So what many people believe is that when a child is prosecuted in the juvenile court system, that they don't have a record that will affect them. They don't have a criminal record, and therefore there's no reason to be thoughtful about keeping that record confidential or expunging that record. Or people think that once a person turns 18, that record automatically goes away. And the fact of the matter is that that's not true in nearly every single state. every single state provides some sort of accessibility to juvenile records to individuals during the court proceedings and after the court proceedings are over. And then many states have some sort of mechanism to get rid of the record, either through an expungement or a sealing process, but many of the states do not have adequate protections. And so we looked at every state laws on how well they protect records, who they're giving access to records to, and who has the ability to use those records against young people, as well as their ability to get their records expunged. We also did a study where we looked at every state and created a fact sheet so that policymakers could use this information to see the gaps in their laws and to better address confidentiality and expungement of juvenile records. And just as Jessica said, this study was done in 2014, and so we're very happy to say that many of the states have made reforms since then. We're currently in the process of working on an update to this and hope to have some more current information as soon as possible.
So let me go back to conditions. Conditions, and we've lumped in education. This is a persistent area of concern. Young people who are held out of home in facilities, and particularly in large prison-like facilities, face a whole host of harms. We commonly hear about young people held in solitary confinement. It's a very common practice to strip search young people, even when there's no suspicion that they're hiding anything on their body that could be found through a strip search. Young people are held in restraints, shackled, sometimes feet and hands, sometimes shackled to tables. They're facing pepper spray and physical abuse and sexual abuse. So these are horrifying conditions and unfortunately not that uncommon. And so, you know, in terms of the work that Juvenile Law Center has been doing, much of our work has focused on litigation to address these issues. So litigation to challenge the constitutionality of solitary confinement, litigation to challenge the use of pepper spray and restraints. And in the context of doing that work, we've learned about that the less facilities rely on these practices, typically the safer they are, because what facilities need to do to address these problems is engage in positive programming, de-escalation, learn restorative justice practices. And so the data tend to support the idea that stopping the reliance on these harsh abusive practices will improve the conditions of young people in facilities. We'll talk in a little while about de-incarceration. The bottom line is what we unfortunately see is facilities addressing lawsuits, improving conditions slightly, and then unfortunately that just the very idea of having tens or 20s or hundreds of young people in one place, it's not a good setup. And facilities tend to fall back to using abusive practices. And so the real bottom line way to address the problem is through moving young people out of facilities. We've also noted here education. When young people are in facilities, what we want to be seeing is that they're getting an education that's on par with what they would get when they're out of the facility, and that they can seamlessly have a transition back to their school so that the credit that they get counts. Unfortunately, what we often see is that they get worksheets slid through a door, or classwork that's well below their grade level, or even if it's a relatively good educational program, those credits don't transfer. So when they come back out of a facility, try to go back to school, they're turned away, or they're told that they're too far behind, and they get frustrated, and there's a very high dropout rate for young people who have been in the justice system. So a lot of reforms happening in that area as well. A lot of states moving away from solitary confinement, a small move starting to happen away from the use of strip searches, significant work being done in different places to increase the quality of education and the ability of young people to transfer credits. But still, a real trouble area is the conditions that young people face in facilities.
And just to go back to a little bit of the consequences of juvenile court involvement, in addition to the consequences of having a juvenile record and having to declare it when you're either filing for student aid or whether you're filing for an apartment application or applying to a job, there are an enormous amount of additional barriers that sex offender registration causes to young people. So when young people are adjudicated delinquent in the juvenile justice system of a sex offense, or when they're convicted of a sex offense in the adult criminal justice system, they may have to register as a sex offender. Now, the Sex Offender Registration Notification Act, SORNA as we call it, was established by federal law. The Adam Walsh Act was established in 2006, and it required states to implement some sort of sex offender registry for individuals who are 14 and older who were found guilty of or of a certain type of sex offense. Now, even before this law went into effect in 2006, several states were registering children, some children as young as 8, 10 years old. What we know about these young people is many of them were victims of sex abuse. Many of them are intellectually disabled. Many of them are acting out based upon what has happened to them. And some of them are sexually exploring through normative teenage behavior. So the range of offenses can be from consensual sexual conduct all the way to violent sex offenses. But what registration laws do across the country is they require young people to register as a sex offender, have that label for sometimes the rest of their life, and sometimes to notify their communities of their status as a sex offender. So that could mean posting a sign on their door that says that they're a sex offender, or even or notifying their employer and their school and their communities that they're a sex offender. The research, the social science research, there's a lot of research, as Jessica mentioned before, that shows children's brains aren't as fully developed, and therefore their decision making is a little bit less complex, and they're less culpable. Well, the social science research on children who sexually offend is also very telling, in that it says that young people don't sexually offend for the same reasons. They don't have the same motivations for sexual offending as adults, and that their recidivism rates are enormously low. From 1% to 3% of young people who have committed a sex offense will commit another sex offense. And so we have done quite a bit of litigation in this area. We were successful in Pennsylvania in eliminating sex offender registration for children under the age of 18, and are now challenging children who are required to register for an offense that was committed before they were 18, but they were prosecuted in the adult system. We're also litigating this issue in a few other states and have been working on some policy reform through legislation as well. And then I briefly mentioned that, when young people are tried in the adult system, that their records look a little bit different, their registration requirements may be a little bit different. So this is another area that we've done quite a bit of work on, trying to eliminate the prosecution of young people in the adult system through challenging transfer laws. We call it transfer when a young person is transferred from the juvenile justice system to the adult criminal justice system. By challenging these laws, challenging when a young person is transferred automatically, just based solely on their offense. So in some states, there are laws based upon the age of the person or the offense that they've committed that require prosecution in the adult system. So that's some of the work that we're doing, is litigating these statutes. And then another piece of our work on youth in the adult system is when young people are prosecuted and convicted in the adult system and sentenced to very lengthy sentences, whether they're designated as life without parole sentences or whether there's so many years that they're functionally life without parole sentences. We've been litigating this issue for many years, before and since the Supreme Court decided a case of Miller versus Alabama, which said that you could no longer have mandatory life without parole sentences. And we've really been seeing a lot of success on these issues across the country. And there is, coming a Supreme Court case very soon that will look at this issue again.
And up on where Rhea left off, just one thing to track also is where the arguments about adolescent brain development are used. And so these, one of the most obvious places is that the courts have said kids are more impulsive, but also more susceptible to change, and also more susceptible to pressure from adults. So all of these factors mean that we should treat them differently for the purpose of sentencing in the adult system, but also for the purpose of what it means to have what it means to be in custody for the purpose of whether or not police must read your Miranda rights, also for the purpose of when is it appropriate to search someone. And so other contexts are things like whether someone was under duress or whether an act was done in self-defense. So keep an eye out for arguments that a young person has acted differently because they actually are developmentally different. They're not just a miniature adult. And the last thing we had, I mentioned briefly earlier, which is this issue of de-incarceration. There's a real move across the country now to recognize youth prisons are a failed system. They cost a lot of money. They harm children. They don't improve community safety. And so what we're seeing is increasingly states around the country are moving young people out of youth prisons and closing down youth prisons. What we're also trying to track is what happens next. Unfortunately, in some states, we then see new prisons being built or new slightly smaller prisons being built. The ultimate goal is really to look at the social science research and think about what works for young people. Young people are not going to be in the system very long. By definition, you'll age out of the system in every state by age 21, or maybe a few have now moved it up to 24 or 25, but that's not a long time. And so what we really want to do is make sure that kids get whatever services they might need, rather than pushed into a prison system that will ultimately harm them. So that was our 30 minutes of the entire history of the juvenile justice system. Turn it back over to Rhea.
And just one more point before we take questions. You have heard us talk a lot about the juvenile justice system, and you have heard us refer to the young people that are involved in that system as children or young people or youth or young adults. And I just wanted to point that out because that's the language that we use is very intentional, that we don't refer to our own children as juveniles. We don't ever use that language. And part of it is because the language, the term juvenile connotes a negative or criminality. And so therefore we really intentionally use other terms when we talk about these youth.
I see that we have at least one audience question about fines and fees, and are they the same or different from bail? So the answer is they're different from bail. There is bail for young people in a handful of states, but typically there's not a bail system. So what we're seeing instead is any number of things. It could be an administrative cost. You need to pay a court fee. Every time a child comes in a hearing, they have to pay $50. It could be a fee for counsel, even when a young person is appointed a public defender because they're too poor to afford their own attorney. They're still being charged sometimes either a flat fee or the cost. We see cost of prosecution charge. We see cost of electronic monitoring, fines, which would be a sanction imposed, and a separate issue, which I think deserves its own conversation, which is restitution. So restitution is payment that would be made to the victim. Similarly problematic in that young people don't have money, and so they can't pay the restitution typically, but which requires a different solution because we do want to come up with policies that compensate victims when they've faced economic loss. And so the solutions are a little different. What we're seeing in terms of the court fees is that the best solution is just eliminate the fee. Young people, teenagers should not be paying for our court system. And in fact, it doesn't work when we ask young people to pay for the court system. Typically, they can't afford it. And the process of trying to collect actually costs as much or more. And so the easiest solution there is just straight out eliminate those costs. And that's what we've been seeing in California and Nevada. We saw similar legislation introduced and not yet passed in Maryland and New Jersey, but we're hopeful. On restitution, I think the conversation is a little earlier on, and we're kind of working through in different jurisdictions what that might look like, a solution that has ensures accountability and restoration, but in a way that works and doesn't depend on young people to do the impossible, which is pay money that they don't have.
So I see that we have 2 more questions in the queue, and I'm also, if you all would like, I was going to also try to turn to open the phone line too. So there is one question here. I think we also are able to follow up with people later too, but one question for Ria: what reasons has research found for adolescents to commit sexual assault as opposed to why young adults do it?
What reason?
What research?
Sure. So the research has shown that the motivations for sexual offending are very different, that they're not predatory, that they're not with intent to harm for the most part, that when young people commit sexual offenses, many times they are engaging in some sort of sexual exploration or acting out based upon sexual abuse that has happened to them. Sex offender registration has not been found to be effective for young people or for adults, to be honest. The recidivism rates for adults is also quite low. It is at maybe 10 to 13%, whereas for children under the age of 18, it's from 1 to 3%. And I think that because there has been no research finding that there is a public safety benefit to having sex offender registration, and the harm of sex offender registration is so severe that there is no real reason to have it any longer. There's been recent research that has shown in just a couple years ago where Dr. Elizabeth Letourneau out of Johns Hopkins looked at young people who had been adjudicated delinquent of sex offenses and young people who had been adjudicated delinquent of sex offenses but were required to register as a sex offender, and the well-being of both those populations. And what she found was that young people who were adjudicated of the exact same offenses but required to register as sex offenders had higher rates of suicidal ideation, higher rates of suicide attempts, were 5 times more likely to be approached for sex by other people on the sex offender registry, by adults on the sex offender registry, and just had severe psychological and just general consequences that arose from their registration obligation.
So another question here: when beginning to address juvenile justice issues, how would you suggest we go about finding sources, since so much of records associated with these cases aren't available to the public?
I mean, the records of the young people, their court records, their law enforcement records are appropriately not available to the public. I think that there is an ethical way to report about young people involved in the justice system, and really trying to ensure that all the research that Jessica talked about, the adolescent development research, is something that is being part of the reporting, where you're talking very specifically about the diminished culpability of young people and how the courts have looked at young people when children's names are used or their photographs are used. It doesn't do anything to further further public safety, and it doesn't do anything to protect the young person. What it typically does is it labels that young person and stigmatizes them. And so we feel very strongly that records of young people who are involved in the court system should remain confidential and should be protected, and they should have the ability to have a future beyond just that one thing that they may have done when they were children.
Another sort of ideas and pointers for how to figure out what's going on, given that it's not like adult criminal court that you can just walk into. There are an increasing number of groups that are driven by youth and families across the country who are, and with both youth and their parents, doing advocacy for reform. I think those are great resources and would be a go-to if I were a journalist, not only to ask them about their own experiences, which they may sometimes want to share, but also to ask them about what's their vision of, you know, what do we do next? How do we improve the system? What's working? What isn't working? So we're happy to share more resources later, but I think really thinking about who's on the ground doing the work, who's leading the work from a position of having had experience in the system will be a good way to give, sort of put meat on the bones of the story, and also in an ethical way that's respecting the expertise of young people who have been involved in the system.
We have a question. Do you see any major reform coming up on a federal level other than the Supreme Court case?
We have one thing, that the bill that's been introduced on fines and fees, which would, this is called the Eliminating Debtors Prison for Kids Act, and it would provide grant funding to states that prohibit the reliance on court fees. So that's promising. It's been introduced by Senator Cardenas. We're hoping that there will be a Senate companion piece. We're keeping our eyes out for that. I'm trying to think of what the other federal reforms are. Do you have a few?
The First Step Act had some language about compassionate release. And so the individuals who I mentioned who are serving very lengthy sentences, they may be eligible for some sort of compassionate release. It's not quite as far as we might have hoped. You know, we would really love to see legislation that eliminates life without parole and lengthy sentences such as life without parole for young people, but that has not been included in the First Step Act as of yet.
The other federal bill that passed recently, and where it'll be interesting to watch state level implementation, is the Juvenile Justice and Delinquency Prevention Act. That was, I think, 16 or 18 years in the making from the last time that piece of legislation was reauthorized, and has some strong provisions around gathering data and making improvements on conditions of confinement, things like solitary confinement and restraints. It also has very strong provisions on not holding young people in adult jails pending their trial, so that if a young person is awaiting trial in the adult system, they should not be held in the adult system. Which I think will have really significant consequences. States have, I think, different amounts of time to implement different portions of it, but I think maybe up to 3 years for that provision. So sort of tracking implementation of the Juvenile Justice and Delinquency Prevention Act in different states may yield some interesting reforms.
There's a question, when it comes to educating young people while they're either detained or in the system, what stories are not being told? What do you think the public should know about?
Well, there's a host of things. I think young people held in solitary confinement are often getting no education at all. So that's a huge story, very problematic. Young people held in the general population in facilities have told us, you know, we think of our teenagers, maybe including my own at home, as sort of not wanting to go to school, not wanting to bother. What young people who have come out of the system have said is that, you know, I really was not challenged enough. Nobody had any expectations for me. Nobody was assuming that I could or should do anything. If I was gifted or talented or cared at all about my education, I didn't have any opportunities to get the kind of education that I would have needed, and I had to redo everything when coming back out. So really finding out about the quality of education in facilities is key. And then the other thing would be to ask young people about how was it trying to get back into school when you left. I think you would likely hear a lot of issues, both with the credit transfer that I mentioned, but even I think sometimes with directly being pushed out of school because schools are wary of young people who have spent time in the system. So looking at every stage, how was it when young people are in, and how was it as they try to transition back out? Those are all great questions to ask.
We have one more question on the question line, but then I was going to open up the phone line too. I'm a bit confused. You mentioned the juvenile cases are confidential, yet before it was also mentioned that states share them regularly and have few protections.
Properly. I think what I heard is that there's some confusion because juvenile records are confidential, but that they are being used and accessed. So juvenile records are not fully confidential, and there are some young people whose some states where juvenile records are not at all confidential. And if you look at the map, you'll see a little bit more about which states are better protecting records and which states aren't. So sometimes juvenile records, when they're available online or when they're available to more individuals, that they tend to have a greater impact on the young person as they grow into adulthood.
Thank you. Okay, I'm going to also try now to open up the phone lines in case anyone wants to ask a question live. One moment.
As you're opening up the phone line, I think one of the other things to keep in mind on the question of records is the distinction between how young people are treated in the juvenile system and how they're treated in the adult system. So young people who are tried in the adult system may face even greater barriers with more of their information being disclosed, even though obviously at the time of their offense, they're similarly young to the young people in the juvenile system. And there's a similar issue, I think, as Ria was describing around SORNA, which is SORNA is revealing information in a much broader way, even when the young person at the time of the offense was 14 or 15 years old.
I think people should be able to speak on the call now. There's also a few questions about the access number, so I'm trying to send the number to call in if people would like to, if people have just been watching and would like to call in. Although I'm not positive, I don't hear anyone, but I'm not sure if that's because there might not be any questions at the moment. We also will be providing the slides and a recording following this.
And our email addresses are on this last slide, so if you have any additional questions, please don't hesitate to reach out.
We'll give it just maybe 30 more seconds just in case people are having trouble calling through, but otherwise we're really grateful that you were able to join us, and we're looking forward to continuing the conversation.
All right, thank you very much, everyone. Have a good afternoon.